Hi guys, welcome back to my channel. This is Battle with Ola. My name is Mujala Olua. Thank you so much for coming by once again. Today I want to answer a question that has so many wings, and so many children, like we say, back in school. Questions that are, A, B, C, D, and E. But essentially, this person, Laura is one of the persons or subscribers to the channel that has asked the most questions, if I'm correct, or that has been frequent in asking questions. And I'm really grateful for that, because the more you ask questions on the channel, you expand the frontiers of the knowledge that I share on this channel, and it gives me a sense of impacting you and impacting the world in general. Because when I create responses to your questions, you watch them, they're useful for you, and they're useful for every other person that gets to watch the video. So Laura has asked a question on how to tender evidence through a witness and from the bar, and how to lay proper foundation. So I'm going to be answering this question in different ways, but I'm hoping that you'll be able to piece the answers together. So I'm going to talk about how to tender evidence through a witness. I've done that already in the video on how to start or open a civil trial, and I think one of the video, I'll leave a link to those videos if I'm able to lay a finger on them, but essentially I'm going to be repeating it. So I'm going to talk about how to tender evidence or documents through your witness, one, and how to tender evidence from the bar, how to tender documents from the bar. Now, tendering of documents is greatly regulated by the Evidence Act 2011 and regulated by judicial decisions. That's case law. I'm also going to be talking about how you can object to documents tendered by the other party, and how to base your objections on law and decided cases. So let's get right into it. How to tender evidence through your witness. Now, evidence can be disputed and undisputed. So when evidence is undisputed, documents now, let's stick to documents. When documents are undisputed, you can tender them from the bar as the lawyer, as the counsel. But when they are disputed, you have to tender them through your witness, so that the other party can cross-examine them and lay all points of dispute, to rest. But if they are undisputed, you might have even agreed with the other party during PTC, that's pre-trial conference, to tender those documents from the bar, and they will not be cross-examined. The other party will not be able to ask questions of them, and the court will admit them. Now, the ways that the court will attach to those documents is dependent on the court. Don't forget that admissibility is governed by relevance. So these documents too have to be relevant. Even if they are undisputed, they have to be relevant to the case and to the bone of contention in the matter. And so the court will attach the weight that's appropriate to each and every one of them in reaching a decision in the matter. So let's talk about disputed documents. For instance, confessional statements in a criminal trial. You tender them through your witness. If you're the prosecution, most likely you will tender the confessional statements through the IPO, or you tender the complainant statements through the IPO, because he's the one that conducted investigation on the matter. So it's linked with the documents. Don't forget that you cannot tender a document through a witness that has no bearing or no link with the document. Usually, documents are supposed to be tendered by the maker of the documents. But in a criminal trial, instead of tendering those documents, through the defendants, you can tender them through the IPO, because it's directly connected with the case and the confessional statements, especially being, the officer or part of the team that investigated the matter and took the defendant's statements. So it's connected to the document, even if he's not, the direct maker, as in the writer, the defendant. So he can also tender the document. In a civil trial, you can tender documents through, the maker or the author or the originator of those documents. Please read your Evidence Act. You can start from like section 80 through maybe 112. I think those are the sections that govern documentary evidence, admissibility and non-admissibility of documentary evidence, and how you can object. So if, for example, I'm starting a trial now, I could tell the investigating police officer, please tell us your name, tell us your role, and your first number or your AP number. So if it's an inspector, so he will tell the court his name, where it's attached to, the station is attached to, the department that is attached to, and his AP number or his force number. And then you will start to question him on the investigation that he carried out in the matter. But let's talk about a civil trial. So for instance, you put your claimant in the box, or you've put your witness in the box as the claimant. Now you ask him to tell the court his name, his address, and what he does for a living. Those are the 3 WH questions: the who, the what, and the where. So after you have said that, my name is Nigerian Law, Livingstones, I live at number 7B, Happy Land Estate, Shangutedo, Aja, Lagos, and then I am a lawyer by profession. So he has told that to the court. Then you ask the question, and then you ask him about his witness statement on oath. You depose to a witness statement on oath in this court on the so or so. You mentioned the date it was deposed to. So don't forget that witness statement on oath is supposed to be deposed to in court. So be very careful the way you word that question. And if your witness is not that smart, please word the questions in a way that will facilitate the answers that you want from him. Do not put your witness in the lodge. Do not leave your witness in the lodge. So instead of saying that, did you depose to a witness statement on oath, for instance, you can say you deposed to a witness statement on oath on the 15th day of October 2021 in the High Court, in the registry of this court. You will say yes. Then if you see a copy of that statement, will you be able to identify it? You will say yes. Then you ask the registrar to show him a copy. So after you have seen a copy, you ask him, what do you want the court to do with it? Now, if your witness is not smart again, instead of saying, what do you want the court to do with it? You can ask, do you want the court to admit this witness statement on oath as your evidence in this matter? That's the smart way to go about it. And then you will say yes. So you just be eliciting polar answers, polar questions, yes, no, from him. If it's not, as smart, or if you can surmise that he's already overwhelmed by the bar. I was just telling, someone that, the witness box overwhelms witnesses. So if your witness is especially a civilian witness, be very gentle with them. Sometimes you might have prepped them so much, and then they get into the box and they're still doing something else entirely. So you have to be very gentle and very smart so that they do not spoil your case and you do not even overwhelm them further. So if you ask that and they say yes, then you say, my lord, the witness seeks to adopt the statement on oath as his evidence in this matter. Then the court will adopt it. That's if the other party has no objection, because the other party would also be shown the statement on oath by the registrar. So if they say they have no objection, the court will admit it in evidence and declare that the witness statement on oath is admitted as the witness's evidence in the matter. Now, if you have other documents to tender, documents that the witness has referred to in his pleadings, that is in his witness statement on oath, you continue to question the witness so that he can, point to those documents, okay? So instead of just saying that he's adopting his witness statement on oath, you can start to question him little by little on what actually transpired in the matter. After adopting the witness statement on oath, if you have other documents that you'd like to tender through that witness, you continue to question the witness, on the facts of the case based on what the witness has stated. Okay, for instance, so what happened? So you ask the witness, why are you here today? So the witness would say that I'm here because so and so person took my land. So you start guiding them so that they don't jump. Okay, I bought a land. They will start, I bought a land from so and so in the year 2012. So what were you given, or what documents did you execute in proof of this purchase? That should be your next question, because you want to tender the document. The witness would likely say, I was given a receipt and we executed a contract of sale, or we executed a sale of land agreement in proof of the purchase. So you ask, if you see the sale of land agreement, would you be able to identify it? Yes. So you ask the registrar to show him. You say, identify his signature and say that, oh, this is the document. Then you show the other party. If they have any objection, they will raise it to the court. If they don't, then you tell the court, my lord, we seek to tender the sale of land agreement. So the court will mark it maybe Exhibit A, and it will be admitted in evidence. Then you show the receipt the same way. So essentially, whatever documents that you want to tender through your witness, ask the witness questions Don't forget that in examination in chief, you cannot ask leading questions. That is, you cannot really ask questions that will show that you are putting words into the mouth of the witness. Aside from the innocuous beginning questions that I talked about to help a witness that's not smart, you cannot really put questions and answers in the mouth of your witness. So you need to be careful. Just guide the conversation, the pleadings out of them. Don't forget that the evidence that is pleaded, that is things that you refer to in the witness statement on oath, if you do not guide or lead your witness to refer to them again while giving evidence, they are deemed abandoned. That's the law. So if the story, for instance, maybe it's a labor matter, if the story is that it was unlawfully terminated or wrongfully, his employment was wrongfully terminated and is owed so amount of monies and what have you, everything that you've stated in your witness statement on oath, you have to lead the witness to repeat those things to the court, so that if there are documents you want to tender in proof of those things, even though you front-loaded them, you can tender them through your witness, and the witness can restate those things to the court, because the court will work by what is on its record, and things that are said in the pleadings, that is in the witness statement on oath, that are not referred to when the witness is giving evidence, are deemed abandoned. So make sure that you lead your witness, elicit information that will lead to the documents that you want to tender through them. So you can say something like you were an employee with a so company. They'll say yes. When were you employed? So just something to guide them to start talking, to start singing like a parrot. So they'll say, okay, in 2019 October, I was employed by so company as their business development manager. So were you given an employment contract, or did you sign or execute an employment contract, when you were employed? Yes. That is your window to tender the letter of employment. Then you tell the court, you show him, you ask him usually, can you identify it? He say yes. The registrar will show it to him. He will say, yes, this is my employment letter. He will show the other party. They will say they have no objections. If they have an objection, they would raise it. We'll get to the objection part much later. So after they say they have no objection, you say, my lord, we seek to tender the employment letter. So the court will mark it Exhibit B, and it's admitted in evidence. Then you ask the next question. You keep asking until you ask up to, the sack letter, because you're trying to build a case of unlawful termination. So you ask questions so that your witness will be able to talk about the things that led to his predicament, why he is before the court. I hope that is clear enough. Please watch the video on starting or conducting a civil trial as well. It will show you how to elicit information, and how to tender evidence through your witness. So now let's talk about tendering through the bar. So if you want to tender documents from the bar, that is, you want to tender it as the counsel in the matter, not through a witness, you have to be certain that the documents are not in dispute. But in any case, the other party can still raise objections. So what you do is you tender it, you tell the court that you seek to tender the document. So you present it to the court, and the court will look at it. If it's a proper evidence, the court will show the other party too. So it could be an undefended case. So the court can actually raise an objection to you tendering it, even if the other party does not raise an objection. For instance, if it's a public document and it's not the original, you have to certify it. So even if there's no other party, if it's undefended, or even if the other party is sleeping on their right to raise an objection, the court can raise objection suo motu, that is on its own, and say, oh, this document is not proper, so it cannot be admitted in evidence. So please read your Evidence Act when you have a trial like this, especially between section 80 to 120, thereabouts. So let's talk about the objections that can be raised to the tendering of a document from the bar. That can help you or guide you to understand, how to tender a document from the bar. The first thing is that when you want to tender a document from the bar, you have to lay proper foundation. That is, that if they are electronic documents, you have to lay foundation according to Section 84 of the Evidence Act. How they were produced, in what manner they were produced, the gadgets that were used to produce them. Were they working in the proper condition? Are they gadgets that are used to produce such documents in the normal course of activities, in the firm or the company or the business place where they were produced? Please read Section 84 of the Evidence Act 2011. So you have to lay proper foundation. For instance, I was in court one day. I give an example. I was in court one day, and it was an undefended divorce proceeding, and the petitioner did not have the original of the marriage certificate. So the lawyer sought to tender the photocopy of the marriage certificate from the bar without certifying it. You know that marriage certificate is a public document. Public documents are mostly documents that are kept as part of public records, by the government agencies, public organizations, public agencies. So their documents, their records. For instance, the police, the court registry, their documents are public documents. So if you are tendering a photocopy of public documents, the Evidence Act says that it must be certified, properly certified. So you have to tender a CTC, a certified true copy. The lawyer was tendering a photocopy from the bar, so the court itself objected to it on the ground that it is the photocopy of a public document and cannot be tendered without being duly certified. So that's it. But before the lawyer sought to tender it, he laid foundation. So laying a foundation can be very crucial to you successfully tendering a document from the bar. But even after laying foundation, the other party or the court can still object to it on other grounds. So that's why I said I'll answer it in different ways, but I hope you can piece the answers together, Laura and every other person that needs this information. So the lawyer laid the foundation by saying that the wife has deserted the marriage for about 7 years. She has not been heard from. She has not been found. She's unreachable. Her last known address, she was not there. So they could not, and she asked, the original marriage certificate with her. So they could not produce it because of that. And that's why they came with a photocopy. That's a proper foundation. But now it had another key leg in that it was not certified. So two different things that can work against tendering a document from the bar. But now let's get back to objections. So I think I've already talked about the first objection, secondary evidence. For instance, the photocopy of a marriage certificate is a secondary evidence because documentary evidence are to be tendered as primary evidence. That is, their originals must be tendered. But if there's a situation that warrants that the original is not available to be tendered in court, and it's the photocopy or some other secondary copy that is available, there are rules and ways to go about it. And you find those rules in section 83, 88, 89 of the Evidence Act. Sections around those sections as well. So if it's a secondary evidence, like I said, it has to be certified. Proper foundation has to be laid. Okay, so if it's secondary evidence, you have to lay proper foundation. That is, explain to the court why the original, the primary document, the primary evidence is not in court, why you are tendering a secondary copy, that is maybe a photocopy. So you have to lay foundation. Oh my lord, there was a fire outbreak and it was burnt and destroyed in the fire. The original was destroyed. So we needed to go to the court registry to demand for a certified true copy. That's a copy that was photocopied from the original that was kept publicly and then certified, So that's a proper foundation. And then you can move ahead. So that's one. The second is section 84 documents. Those are electronic evidence. That is, if you're tendering, for instance, a photo that was produced from a video camera, if you're tendering, for instance, printouts from emails, WhatsApp conversations, if you're tendering discs, if you are tendering a hard drive, or rather a flash drive, electronic evidence in general, you have to lay foundation according to section 84 of the Evidence Act. And those sections say that you have to come with a certificate of compliance. Certificate is usually a one-pager or at most 2 pages. So you edit in the heading of the court, you put the case, the parties, the suit number and all, and then you say certificate of compliance according to section 84. And then you start, the deponent will start saying, I, Mujila Houseoflivingstones, female, lawyer, Nigerian citizen of so departments. So you link yourself to where the document was produced if you are deposing to the certificate of compliance. Okay, I work at so business center and we produced these printouts of emails when our printer HP LaserJet blah 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 was working in its proper condition. We printed it when during the normal course of activities of the printer. We printed it we printed the information that was supplied to the printer. That was the information we printed out. All those things, you find them in section 84. There are about 5 or 6 paragraphs. So once you're able to do all that, then you depose to it, you sign it, you date it, and you sign it. So the obligation of it being stamped by a commissioner for oath is really not necessary as far as I've seen in practice, although there are people that may have an objection to this. But generally, the one that I've done, that I filed in court, they were not certified or stamped by the commissioner for oath. They were just deposed to by the deponent that we mentioned in the first paragraph. So once you've done this, you have laid foundation according to the requirements of section 84. So you attach that when you are tendering those pieces of evidence. So that is how to do it. You can read Kuba and Dixon, or you can read Dixon and Sylvia. Those are case laws. I think Dixon and Sylvia is a 2016 case. So those are case laws that establish certificate of compliance as a requirement for tendering documentary electronic evidence. So that's two. The third objection that you can raise, to the admissibility of the tendering of documents from the bar is that the documents were not pleaded or front-loaded. So by pleading, we mean that the documents were not referred to in the claimant's or the petitioner or the other party's witness statement on oath or their originating documents. That means that they did not even mention those documents. The case that they brought to the court has no bearing with the document that the counsel now wants to tender from the bar. So no nexus at all. So you can plead, you can object on that basis, because admissibility is governed by relevance, don't forget. So if someone is bringing a document that has no bearing whatsoever to the case and has not even been mentioned in the originating processes, you can object to it being tendered, and the court might sustain your objection and reject the document in evidence. So that's another leg of objection. Then you can also object if someone is tendering a photocopy of a certified true copy of a public document. Don't forget that public documents can only be tendered as certified true copies. Certified true copies of public documents can be tendered. You know that the public body or the organization or the government agency is the owner of the original copy, so they will not give it to you, but they will make a photocopy for you and certify it properly according to the rules of certification. So if it's been certified, you can tender it. So you cannot now photocopy the certified true copy of a public document and then tender it. I hope that's clear. So you can tender a certified true copy. That's a photocopy that's been certified. But you cannot make further copies of that certified true copy and tender it. No, the other party would object to it. And it's a very viable leg of objection that can be sustained by the court to reject your document in evidence. And if a public document is not even certified at all, you just photocopied it, it will not be admissible in evidence. So the first thing I talked about is not laying proper foundation to tender secondary evidence, that is like photocopies. Then I talked about section 84 documents, how they have to be accompanied by a certificate of compliance and foundation laid in that regard. Then I talked about documents that have no nexus to the case at hand, that is documents that were not pleaded nor front-loaded. Now I've also talked about photocopies of public documents. You cannot tender them except they are certified, and then even after being certified, you can only tender the CTC copy. You cannot tender a further photocopy of the certified true copy. So please take note. And if the document is not properly certified, you cannot tender it. You know that if you look at section 104, it talks about how to certify photocopies of public documents. The certifying officer has to put his name, his role, and signature, date it, all of that. So it has to be complied with. So if it's not properly certified, it will be objected to as well, or you can object to it. It cannot be admitted in evidence. And also another leg is an unsigned document. An unsigned document is a worthless document. The court cannot act on a document that has not been signed, so it is not admissible in evidence. That means that the other party can raise an objection that this document was not signed, so it's worthless. It cannot be used to assist the court in deciding this matter. So what's the point? Another leg of objection is private documents that are already kept as public documents. For instance, if you write a petition to the police, it's a petition originating from a private person. So it's a private document. But once it gets to the police, the record of the petition that the police has kept as its own records is a public document. So you have to follow the procedure for tendering public documents, even though it was originally your own private document. So you cannot come to court and tender your own copy of the petition. Rather, you have to get a copy of the one that was received by the police and certify it before you can tender it, because it is now, a photocopy of a public document, and it has to be certified before it can come into evidence. I hope that is clear. So those are instances whereby you can object to the tendering of a document from the bar. And please note also that if you do not have the originals of a document, you can issue a notice to produce to the other party. If you're sure that they have the document, you can issue a notice to produce to them to produce the original so that it can be tendered in court. Now, the court, there have been decided cases to the effect that issuing a notice to produce does not mean that the other party will actually produce it, but it gives you the express leeway, to actually tender the secondary evidence of that document. So once the court can see that you actually issued a notice to produce, it is part of the build-up as a foundation laying for you to tender the secondary, evidence of that piece of document. So that's essentially how to tender documents from the bar and how to tender documents through your witness. Also note that when you're tendering documents through your witness, the other party can also object on different grounds. For instance, like I said, if the person you're tendering the documents through, the witness, is not the maker or the originator of the documents, and the maker is readily available, why tender it through a third party? And several other, objections that can be raised according to the Evidence Act. Please read your Evidence Act in advance for any trial, especially where documentary evidence will be tendered, so that you will not be unpleasantly surprised. I hope, Laura, that I've answered your question, and I hope that everyone that watches this finds value in it. Please subscribe to the channel and leave me comments. Let me have feedback from you. I will always see you in my next video. Toodles.